this is a forum that's open, that the public can speak about anything they want. And I was asked, why is it a limited forum, and cite the authority? Well, I wanna have it on the meeting record, that the Office of Attorney General, in an opinion issued in 1995, opinion number 95-311, was asked, can a legislative body prohibit members of the public who speak during public comment, limit those comments to only items within the subject matter jurisdiction of the body? And the answer was yes, the legislative body can limit public comments to those comments related to the business of the district. Now, where did that come from? The opinion talked about Government Code 54954.3, which states expressly, every agenda for regular meetings shall provide an opportunity for members of the public to directly address the legislative body on any items of interest to the public, before or during the legislative body's consideration of the item. That is within the subject matter jurisdiction of the legislative body. Now, the Attorney General went on to say that to conclude otherwise would require us to change the language of section 54954.3 to state, for example, within or without the subject matter jurisdiction of the legislative body, which it clearly doesn't say. Now, we also know that there is a federal constitutional right to free speech, as well as a California constitutional right to free speech. That analysis was also undertaken by the California Attorney General, and they looked to the case of Perry Education Association versus Perry Local Education Associations from 1983, a U.S. Supreme Court decision, and they quoted some of the language from that decision, which says, public property which is not by tradition or designation a forum for public communication is governed by different standards. We have recognized that the First Amendment does not guarantee access to property simply because it is owned or controlled by the government. The state may reserve the forum for its intended purposes, communicative or otherwise, as long as the regulation on speech is a reasonable one and not an effort to suppress expression simply because we disagree. So we can talk about what this district's business is, and tonight, as Mr. Staples pointed out, there's no agenda item on the Wellbeing Center, there's no agenda item on abortion, there's no agenda item on gender affirming surgery or gender affirming therapy. Those are not on the agenda. And so we need to keep our discussion to district business. Now, also in that opinion, they note that the California courts also follow the rule of a limited public forum as set forth in Perry. So, and this was actually litigated by the Ninth Circuit in this case of White versus the City of Norwalk from 1990, and therein too, the court was explaining that the in meetings of City of Norwalk, and let's see where I have it right here. We are dealing with meetings of the City Council for Norwalk and with speech that is addressed to that council, and we're not talking about First Amendment broadly, like you might have outside on the sidewalk by the street. So I want the audience to understand that we're not making this up. So please honor the public comment process as set in the government code and set by our policy.